And thank you, Jody. And good evening to everyone. I am Dr. Love Jones. I am the Director of the Human Rights Department with the City of Greensboro. Welcome to the Human Rights third installment of Let's Talk Law, Plea Bargains, Parole, and Probation. I want to stress how grateful we are as a department to support a commission such as the Human Rights Commission that takes it seriously, the needs of the community in order to talk about how navigating the judicial system butts up against the issue of human rights. One of the critical parts of human rights work is providing access to information and therefore empowering people. But many times when it comes to navigating our judicial system, people who lack information and access thereof often lack the ability to engage in agency on their own behalf in an ideal kind of way. So it's really important for community members to be able to spread the information learned this evening, for agencies to capitalize off their understanding of the information provided tonight, and making sure that impacted populations get access to this information as well. Very grateful that this is going to be recorded and made available to participants. Therefore, there's the ability to spread the word. So again, very grateful to be on the administrative side of supporting such a dynamic commission. Thank you to the commissioners for definitely investing the time and energy in developing a program such as this. I'm very excited about the Let's Talk series as a whole. So with that being said, please commit yourself to following this series. Also commit yourself to becoming more educated on how to participate in the development of these kinds of programs. There's several ways to volunteer and support the HRC. One is to be appointed by a council member by way of submitting your name in the city's data bank for boards and commissions. But the other is simply to contact members of the commission and/or the department, and Jody will provide that contact information. But definitely there's an opportunity to simply volunteer on the things that are near and dear to your heart as critical topics. So that's for those who need a shorter term commitment. Again, really grateful for this opportunity to learn on this evening. Look forward to your participation beyond this series. And I want to turn it over into the hands of our Commissioner, Sue Polinski, to kick off the program and introduce our speakers for the evening. Thank you.
Thank you, Dr. Jones. I'm Dr. Sue Polinski, and I am glad to see everybody here. Welcome. This is our third installment, our third night of Let's Talk Law, and we have two really amazing speakers for you. I'm not going to go into a whole lot of pre-stuff other than just a little bit of housekeeping. If you have a question, and we want you to ask questions, there's time at the end for questions. Please put those questions in the chat. They'll go to Jody or me, and we'll ask them when we're done. And other than that, we've got some pretty good speakers tonight. So let me talk to you first about Sharon Dunmore. I knew I liked Sharon when I first met her because she comes from Brooklyn. But she is a North Carolinian now, went to Guilford College and Elon School of Law. She is the Chief Executive Officer for Triad Legal Group. And before I start telling you about Sharon's qualifications, did you know that we had a 501c3 nonprofit law firm in Greensboro who provides legal help to people whose families make up to 400% of the poverty level. And that's the numbers I have are for the 2020 poverty level. And if you qualify, you can, and you're perhaps don't qualify for public defender, please check out triadlegalgroup.org. Now, Sharon is actively involved in all kinds of organizations, from the Greensboro Bar, the NC Bar, the Young Lawyers Division of this. She is amazing with what she's involved in. She has worked in immigration law. She's won awards for trial competitions, and she has done pro bono work. including being the liaison for the Elon Law Hispanic and Latinx Student Association. The belief of her organization, Triad Legal Group, is that every person deserves an attorney, equal access to the legal system, and equitable access to justice. And with that, I'm ready to just turn this over to Sharon, who's going to talk about plea bargains and what that really means. Sharon?
Thanks, Sue. Good evening, everyone. It's great to have you all coming out for this web series, and I am honored to be able to speak on behalf of the local level plea bargains here in Guilford County and statewide across the state of North Carolina. So before we get into the nitty-gritty of what a plea bargain even is, I would like to go ahead and define a couple of terms that I'm going to be using during this presentation so we can all make sure that we're on the same page. So first and foremost, I'm speaking on the state level of plea bargains. We're not talking federal level, we're talking state court. So in Guilford County, for example, there are 2 jurisdictions that the state court covers. And those 2 jurisdictions for criminal cases are district court and superior court. Now we're going to break that down even more. District court is where misdemeanor cases, traffic infractions, traffic misdemeanors, and felonies that have not been indicted to superior court are heard. That's the jurisdiction of the district court. Superior court hears criminal cases that have been indicted by a grand jury. And for those of you that don't know the definition of an indictment is when someone is formally accused, when there's evidence that is brought to a grand jury and they review that evidence. And at that juncture, the grand jury is able to determine this person could be found guilty of this crime, or there's enough evidence here that this person can be pursued on a felony level for the state to seek these charges formally against that individual. Now, let's talk about plea bargains, because I know that's why we're all here. So a plea bargain is when there's an arrangement between the prosecutor and the defendant, and if you have an attorney, through their defense counsel, but it's on behalf of the defendant. And that's typically where the defendant will have some kind of agreement where they may plead guilty to a lesser charge. There might be charges that are dismissed. And that's in exchange for a more lenient sentence, essentially. So, So different plea bargains come in different shapes and forms. And I wish I could tell you that there was just one way that they come out, but there's no rhyme or reason to it. There are a lot of ways that a plea bargain can be incorporated into someone's criminal proceeding. So typically, there are plea bargains that are offered for individuals who qualify as first-time offenders. So you have a clean record, you don't have any prior criminal history, and you were in the wrong place at the wrong time, or you were caught up with the wrong group of people, or whatever it may be, but this is your first ever offense. Depending on what the offense is, the district attorney's office, who is the person that would be providing the plea offer to the defendant, is the one that will then say, you know what, we're going to give you a second chance. We understand that you got mad one time, or you shoplifted from Walmart and you stole allegedly $5, $10 worth of products. We're going to have you engage in a shoplifting course, or go do community service, because that's going to right the wrong that you did to society. Or you have anger issues, why don't you go to anger management? You're having issues with, co-parenting your kids, why don't you take a parenting class? Those are typically things that would be involved in some kind of first-time offenders programs. A plea offer can also be offered for individuals that suffer with drug addiction, drug abuse, or even mental health conditions. So typically, if you're charged with an offense in North Carolina, then if you qualify under certain circumstances, let's say you have an extensive mental health history where you have been committed for years, and you are on and off your medication, and there's a record that the defense can provide to the state showing, listen, this person's not doing this because they're willingly committing crimes, it's because there's something more to it, then the courts can take a more rehabilitative approach, and then they can provide some sort of alternate relief. Another way that a plea bargain can happen is by making what we as attorneys call shuck deals. So when I go to court and I'm speaking with the district attorney and I'm providing all of this information about my client to the DA, trying to get some kind of reduction, one thing that I might offer up is, hey, there's some restitution amount, there's some monetary amount to this offense that is outstanding. Someone feels that they are wronged and they are owed a certain amount of money. You know, someone's lawnmower was broken. Someone says that a handbag was stolen or money out of a wallet was taken and not recovered. A nice way that we can talk to the district attorney's office is say, my client will go ahead, they will pay the $72.89 to replace that lawnmower in exchange for a dismissal. Now, those are all things that would qualify as plea bargains here in North Carolina, because again, remember, you are making some kind of agreement with the district attorney's office to have some sort of reduced lesser offense or a dismissal. A dismissal would constitute a plea bargain in some situations. Now, in some situations, when you do have a plea bargain, there's something called a deferred prosecution that comes into play. And a deferred prosecution is essentially that same agreement with the DA's office, but the defendant is signing an admission of guilt. So let's say you are going to enter into that first offenders program. The district attorney's office is interested in a conviction. We, on the defense side, are interested in mitigating whatever my client, the defendant's sentence is, and getting the best possible outcome. So we're looking at this at two different ways. But what the district attorney's office wants is they want some sort of leverage over the defendant. So what they'll do is they will have the defendant actually sign a formal document that says, I am guilty of this offense. However, if I complete A, B, C, X, Y, and Z by this date, these charges will get dismissed. So that's a way a plea bargain can also come about. Now, when I was getting ready for this presentation, I was thinking of questions that my clients ask me on almost a daily basis, and that's how I'd like to approach this discussion with you all today. So I wanted to address what types of charges here in Guilford County that you potentially cannot get a plea offer for or a plea bargain for, because you're not entitled to a plea bargain, you're not entitled to a plea offer, and it's really at the discretion of the district attorney who's in court during that session of court. So in Guilford County, our elected district attorney, Avery Crump, has taken a stance against domestic cases. If you are charged with a domestic criminal case, and this is typically out of district court, so again, we're in misdemeanor land. In district court, they have a strict plea or trial policy here in Guilford County. That includes if your spouse, a family member, a boyfriend, a girlfriend, whoever presses charges against you, whether that is generated by a police officer who was called out to the scene, or that person went on their own volition to the magistrate's office to press charges against you. If it is a domestic case, there is a strict plea or trial policy. You will not be able to work out a plea offer in a majority of those situations, because either you're going to take it to trial or the defendant is going to have to plead guilty. That's how that rolls out here in Guilford County. Another situation where plea bargains are typically not offered at all, where our elected DA has taken a stance again, is with high-speed traffic offenses. So if you are going 90 over, there is no way around it in Guilford County. And I'm not speaking for any other counties but Guilford County, because that's where I primarily practice. If you are driving 90 over the speed limit, you are going to have to either plead guilty to that offense or take it to trial and have a trial in front of a judge in district court to determine whether you're guilty or not guilty of that offense. So I wanted to make sure that we were all aware of those two exceptions that generally in Guilford County, you will not be eligible for a plea offer. Another question, do you need an attorney for a plea bargain? No, you don't need an attorney, but it's always a great idea to have an attorney. And generally speaking, it's my philosophy that everyone should go to court with counsel. There's a reason why we have to go through the grueling years of law school and taking the bar exam and understanding and fully getting that competency of what the law means, because the law is so nuanced. The district attorney is they can go ahead and offer someone a plea bargain, but what good is that if you don't understand what you're about to agree to? Or what good is that if you're not understanding how that could potentially impact you in the future? And those things are incredibly important because a plea offer now can most certainly affect you later. And if you don't know how it's going to affect you and you are blindly and willingly and openly trusting the district attorney's office, who's the office that pressed charges against you, you need to have a better understanding of what's going on. Now, our district attorney office here in Guilford County, I've had great experiences working with those prosecutors, and I have seen them working with pro se litigants, and it's fine. But it's always good to have someone in your corner that can explain it to you and make sure that they're going up to bat for you and making sure that they're getting truly the best possible offer. Now, that also brings me to something else. A lot of people wonder, I can't afford a private attorney. I was given a court-appointed public defender, or I have a court-appointed attorney. Am I going to get the best offer even with court-appointed counsel? The answer is absolutely yes. And let me tell you why. I am a private defense attorney. I take court-appointed cases as well. So if you are eligible for court-appointed counsel and there is a conflict with the public defender's office, guess who they fish that case out to? Me and my colleagues that are on those lists. And we are all in the same boat. We all practice in front of the same judges. We're all in the same courtrooms. We're all handling the same kinds of cases. And I would argue that having a public defender, you're actually at an advantage because their office is in the courthouse. All they do is eat, sleep, and breathe criminal law. They have access to resources that I would have to go out and pay for, or I would have to get a grant for. They have investigators that are on staff, and they have access to all kinds of mental health opportunities for clients. They can get documents so much faster than the standard private attorney. So that's something to keep in mind. It's not a disadvantage. I will tell you, when I was in law school, where did I get my criminal law experience from? I interned at the public defender's office because I knew that that was going to be the best place to really be on the ground and see where everything was and see how it was done. And truly, a plea offer, you might be offered something from a district attorney and it could be okay, but it's not about what the offer necessarily is. It's about how your attorney is going to argue that or counter that or provide information to counter what the district attorney is alleging. Because again, these are allegations against you. And then I have a lot of clients that will ask, well, why are we waiting? I was charged a month ago, and why are we not moving on this now? Why are you not asking that my case get dismissed? Timing is everything. Remember that saying when we were all kids, knowledge is power, information is power? That stands true today. It is part of my job as an attorney to feel out my opposing counsel, who the district attorney is. See how they feel about this case. How invested are they in this case? Let me talk to some police officers while I'm at it. Let me see what they recall. Let's see if this district attorney is going to take a super strong stance against this. That is going to impact how I approach them. I'm not going to come out the gate, like a pit bull trying to fight when that's not the demeanor that I'm being matched with. And I need to make sure that I'm matching that for the benefit of my clients. and to try and get the best possible plea offer or plea bargain. Now, we also in Superior Court have to wait for documents called discovery. That is when you make a formal written request to the district attorney's office and request all of the information that they have in the case. I tell my clients day in and day out, I need to wait and see what the discovery says before we do anything prematurely. Because the worst thing you can do is do something prematurely, make a premature request, and that request just ruins everything. Because plea offers can be pulled out. There's a time limit on them. The district attorney does not have to extend one to you. That is not a right. It absolutely is not. It is an offer, and they can withdraw that. Now, if you're in custody and you decide that you're going to reject a plea offer, because that's something that you are entitled to do. If the state offers you something and you're saying, no, I am not accepting that. I'm not pleading to, out of the 12 charges, I'm not pleading to 10 of them. What's the plea offer in that? Or no, unless you dismiss this, I'm not pleading to this. In those situations, the DA, they don't have to keep that plea open for you. They really don't. They can go ahead and take that rejection as, let's queue it up for a trial. And guess what? If it's in Superior Court, those cases get pushed out months and months. We are having cases calendared now for 2023, late 2022. And that's just how, with COVID, that's how everything's being impacted. But you run the real risk of, if you are rejecting pleas and you're in custody, you could be putting your case into trial posture and you're not entitled to another plea offer. So once the offer goes away, that could be it. Keep in mind, if the state has things over you, for example, you're in custody and you need to file a bond motion to get out of custody, they can try and say that you might be a flight risk because you rejected this plea offer that they extended and they believe that you're not going to come back to court if you're released. So again, this is why it's helpful to have an attorney to assess all of that, to assess the risk for the client, and to then provide that advice as to whether this is a good offer, you should take it. If we accept this offer, this might impact you in the future. If you are on probation for this offense, or if you pick up new charges in the future, how is that going to impact you? And it's really important that we understand all of those moving parts because there are a lot of moving parts. Now, your criminal record can also impact the type of plea offer that you receive. In some cases, that could mean there is no plea offer. If you are charged with an offense, let's just say you are charged with a larceny, stealing, and you have prior convictions for that larceny, the same offense, different conviction dates, but you have been convicted of larceny 5-6 times in the past. The state or the district attorney's office can say, no, this individual keeps committing the same offense. I am not offering something. They can plead to the offenses or we can take it to trial. And then you're kind of between a rock and a hard place because what do you do? So it's very important that as plea offers come in, you're fully informed, you're understanding exactly what is in that offer. Let's go back to those deferred prosecution examples that we talked about earlier. Let's say you plead guilty to some offenses and there's a component of that that says John Smith has to complete 100 hours of community service and pay $5,000 in restitution. Guess what? You have signed up for a plea offer that may be beneficial to you because you're getting a reduction in whatever the underlying charge was, but you also have these other conditions that you have to comply with. And you need to make sure that you are on top of that, because if you don't comply with the terms of that offer and you're on probation, which we're going to get into in a later segment, then you can be violated for violating the terms of your probation. But a plea offer is something that you are willingly, freely, and voluntarily agreeing to. You understand. I'm sorry?
We have a question that was
Sure.
about something that you were talking about just a moment ago. And I thought maybe you could answer that before we go on to the second half.
Sure.
And the question is, are defense attorneys required to inform their clients of all their options, or are they tasked with convincing the client of the option the attorney feels is best?
So this is where I'll start with that. It is not our job to convince our clients of anything. Oops, I'm sorry. I have motion sensor lights. Sorry, everyone. There we go.
There you go.
It is not our job to convince anyone of anything. It is my job and other defense attorneys' jobs to be the client's mouthpiece and use our legal toolbox to make sure that their legal rights are not being infringed upon. Now, when it comes to court, you are absolutely correct that it is our job to inform our client of everything that's going on in their case. I have the tools to navigate the legal system. I can explain why certain things might be beneficial, why certain things might be detrimental. It's not my job to convince anybody because ultimately it's their legal matter. So we present all the facts, we present all the information. With our experience, we can say typically, these are the things that are going to hold up in court. These are things that might be unfavorable towards you. These are things that we can overcome those issues with. With that being said, this is the offer that you're being offered.
Hey, Sharon, I've got, we're going to move on to part 2, but I've got a bunch of questions coming at you during Q&A, but that was great. That was extremely helpful. And I'd like everybody to put the rest of your questions about plea bargains into the chat. Jody and I will get them to Sharon during Q&A. I'd like you to meet FJ Carney. He is a former Greensboro police officer with about 20 years of federal law enforcement experience with the Department of the Navy, the Department of Treasury, the Department of Homeland Security, and currently with the U.S. District Court, Middle District of North Carolina. I don't know how you do all that in just 20 years, but that's pretty exciting. He currently supervises a high-risk caseload, and his goal as a specialist U.S. probation officer is to protect the community and provide individuals under supervision with the opportunity to change by helping them assess and manage risk factors, develop cognitive skills, and utilize resources in the community as people learn to lawfully self-manage their conduct during re-entry. He's also an Elon grad. So we've got the Elon team here tonight. So FJ is going to talk about probation, and it's all yours.
Thank you. Good evening, and Sharon, that's going to be a tough one to follow, but I'll do my best. I wanted to take a moment to thank the Human Rights Commission for the opportunity to speak tonight about the United States Probation Office. Before I get into it, though, I want to mention that I'm speaking as a representative of the United States Probation Office, specifically the Middle District of North Carolina. As Sharon was specifying that she was highlighting the state system, I work for the federal system and I don't have any experience in the state system on the probation side. So I am not speaking for North Carolina State Probation. And it's very important for the audience to understand that there are two distinct and separate systems. And to make it that much more complicated, the Middle District of North Carolina is one of 94 federal court districts throughout the nation, but we are part of a national system. And there are some nuances between the districts. My hope tonight is to provide us a little insight, or provide the listeners to the insight into the U.S. Probation Office. We're commonly misunderstood. A lot of people don't even know who we are, or that the fact we exist. And I want to give you an overview of how we fit into the federal judicial system, the system of justice. And the way I'd like to do it tonight is start at about 30,000 feet, and then we'll drill down into some of the specifics about the mission of the U.S. Probation Office and how we go about attempting to accomplish this mission. But before I jump into that, I think it's real important as an employee of the federal government, and more importantly, a representative of the United States court system, that we start the conversation highlighting two notable but overlooked historical documents, because they're the foundation of the government, and it affects every single one of us that are on this virtual presentation. The two documents in question are the Declaration of Independence. More specifically, I highlight that because it encompasses our beliefs and our values to our rights of freedom and justice, as well as fair opportunity. And then the Constitution, I think, is really important and often overlooked, because that's the foundation of our government. And for those of you that might recall some of the stuff you learned in middle school and high school, the Judicial Branch was formed under Article 3 of the US Constitution. And it brings to question the responsibility of the court system to balance people's individual liberties along with social order. And the way I do that, typically in my mind, is just thinking of a pendulum back and forth. The US Probation Office, our statutory authority comes from 18 USC 3603. And I'm not going to read a statute, nor do I claim to be a legal scholar, but it essentially says, hey, your job is to keep the community safe. And how you do that is you keep the court, the US court, informed, and we report people's conduct. Equally as important, giving the people that we supervise. You might hear me refer to somebody as a client or an individual under supervision, but giving those people an equal opportunity to bring about improvements in their conduct and their overall condition. And I think it's also important to bring out that the goal of our office is not to put people back in prison. The goal is, as you said, Sue, how do you teach somebody to lawfully self-manage themselves? And it's a process, and it's hard. But I wanted to make sure that we highlighted that, because in so many cases, when I sit down and initially speak to people, we are a federal law enforcement agency, but we live in a very gray world. And I can tell you from my experiences that you highlighted in the beginning, it's been an interesting evolution for me, because as, say, a Greensboro police officer, you have a crime, you find a suspect, you develop the case, arrest the suspect, go to court, and that was more or less the end of it. This job is really interesting because now, and I'll break down how our office is subdivided in a second, but now I have the opportunity to meet people coming out of prison. I have a wealth of information on them that we have gathered in advance of the judge even sentencing that person. And you really get to know their condition and who they are and their families and kind of what led them down the path that they ended up on. So as I mentioned, we're in the Middle District of North Carolina, we're broken up into two separate units. One is the Court Services Unit, and I can't speak a great amount of them because I don't work in that unit. But the easiest way to comprehend their job is they provide detailed background information to the judges, so the judges can make informed decisions when they come about sentencing people. I like to think of them as the first face that a client or an individual is entering the federal judicial system. It could be the first face they see, and they work very hard to present a very neutral and positive experience as they enter that system, because it can be pretty scary for people coming from the state and well, not always, but many people are in and out of the state system before they go to the federal system, but it's not a required criteria. I work on the supervision unit, as I said. So after people are sentenced, and they go serve their term of imprisonment, you might hear me use the term term of supervision or supervised release. That is what most people nowadays come out to serve, and it's their reentry, but it's under the microscope of the court, which I guess actually I'm going to mix up my notes here a little bit. Because of the title of this seminar, I mean, there was a question about, what's probation, what's parole, and what's supervised release. The easiest way I like to think about it, even though we are called the United States Probation Office, typically what we see most of now is a term of supervision. And a term of supervision is imposed by the court at the time of sentencing, and it's to be completed after they are released. So it's kind of a twofold, a term of imprisonment and then a term of supervision. And I think it's also important to recognize that the term of supervision is not supposed to be an extension of the punishment. The punishment is prison. When they come out, that's the term of reentry. That's where we're here to help people be successful when they come out. Now, the reality of it is there are a certain percentage of people that they make bad decisions and they violate, as Sharon had mentioned. And unfortunately, they might go back to prison. And with the high likelihood that they might come back out and be put on supervision again. But to just clear up some terms, that's supervised release. So that's it's imposed by the court, part of the judgment to be served after their sentence. Where probation, where I think of it more of as a kind of a conditional freedom in place of going to prison. And then parole's, can't say I know a whole lot about it because it was abolished by Congress, I believe back in 1984. And it's not to say that we don't see people coming out and we help supervise people on parole. But I think it's a crime before roughly 1987. I think it's November 1st, 1987, on or before they could be on parole. And that parole is basically a time period where you could be released early, but under conditions. So I hope that clears up some of the terminology. So then how do we supervise people, taking into account that we're trying to change behavior, but we're also trying to manage risk. You turn on the news, you see what's going on in the community. It's a scary time. Violence it's out there. And I'm not here to say everybody that is coming out is involved in that, but there is certainly a percentage. Well, I can tell you the first thing we try to do is develop a relationship with people. That is number one. And we will work months in advance of their release to develop that relationship. And what does that look like? I can tell you people from our office here in Greensboro go to Butner and we meet with groups of inmates that are getting ready to come out, and we try to answer their questions and develop the relationship before they even come to the halfway house. Some of you may or may not know there is a halfway house called Dismissed Charities here in Greensboro. That's yet another place where we try to intercept them and develop that relationship, more or less telling them who we are and giving them a glimpse of how we operate. And if I can backtrack just a tad bit, I mentioned the meetings at Butner, but the case managers in Bureau of Prisons, again, I work for the United States courts. I do not work for the Bureau of Prisons, but the case managers at Bureau of Prisons will send us information related to their release. Again, it could be a year, 18 months out in the best case scenario, where they're saying, hey, I want to live here with these people. We'll go out and we'll investigate those homes. We'll take into account the physical structure, the people they're living with, the neighborhood, everything, with hopes that when they come out, they're going to be put into a place where it will help them be successful. And I think that's important, even just the physical structure of a home, because if you are coming out and you don't have that support, we're going to see that as a barrier. Because if you're thinking about where you're going to rest your head at night, you're not going to be thinking about some other detailed decisions you need to make that could put you in high risk situations. And then when they do come out, we we fall back on research and we assess people, and it's not just one assessment, it's ongoing assessment. And what does that look like? The best way I try to explain that to my clients is I'm getting old. And if I start having chest pain and pain radiating down my arm, well, it's probably a sign of a heart attack. And I'm going to go to a doctor, and the conversation is going to sound something to the effect of, well, do you have a medical history of heart disease? Well, yeah, my dad died at 71. Do you smoke? Again, I'm making this up, 2 packs of Newports a day. Do you exercise? Nope. Play video games all day long. Do you eat well? No. Bacon and chocolate. That's my thing. Why do I tell you that? Because if you translate that into our probation world, you might get into let me rewind. Your pre-sentence report is like my genetic makeup. That's on the medical side. It is what it is. It is a factor. The things that you've been involved with criminally and in your family, they do have some weight and value to the decisions we make based on to assess your risk. But also, what decisions are you making? Who do you associate with? Every mother has told their son or daughter, you are your friends, whether you like it or not, they have an influence. Alcohol, drugs, mental health, all those things are risk factors. And I won't bore the audience tonight of how deep we get into the weeds, but we get into, are they a planner? Are they a more impulsive person? And we try to dissect that, because I think Sharon said this in her speech, information's power. And it's not something where we're going to get it and we're going to look at it, we're going to hold it from the person. We're going to want that person to be involved in that process. When I say we, probation officer and the client, we make the plan, because I'm not going to impose my will on somebody, because then you're not going to have the buy-in. Now, mind you, there are certain conditions and expectations that the court, tells the person they need to follow. But it brings to point, we are risk-based supervision. The easiest way to look at that is high, medium, and low. If you are a high risk, we are going to try to put as much effort into you as you need to keep the community safe and to help you out. Whereas on the other end of the pendulum, you have a low risk. And research out there says that if you treat a low risk like a high, it's probably going to have a negative effect on that low. And then, common sense would tell you it's an allocation of resources too. We are going to go to where and what we are seeing and formulate the plan. So then we talk about that's the risk, the high, medium, and low. Then we get into what do these people need to be successful? And that's where we get into that targeted approach to some of those risk factors we discussed. And then the interventions. And it could be, I don't want to say simple, but it could be referrals to treatment providers for substance use and or mental health. But a lot of it has to do with stuff we do here in the office. We are seeing people at their highest highs and their lowest lows. And it's amazing at how much people will tell us. And obviously people don't have windows on their foreheads, and I can't see what they're thinking. So we try to figure out what they're thinking by the way they're behaving and the statements they're making. And then we might dissect those types of situations with thinking models, which is it's a fairly basic model, but it's amazing at how fast things can happen. And we try to it all begins with people recognizing those risks, those stressful situations that might be out of their control, the thoughts that they're generating with the belief that your thoughts are driving your behavior, and get them to slow it down and maybe see the situation, the exact same situation, from a different perspective, with hopes that they can generate a better behavior, which would ultimately end to a better outcome. I tell my clients, I'm not expecting home runs. Reentry is hard. I can't imagine what they go through day in and day out. I try, but I know I can't actually be in their shoes. But I do live and breathe this. How do we do it? Other than the things that I've already mentioned, I like to think of myself as wearing a lot of hats. You heard a little bit about my background, and it was pretty law enforcement heavy. But I've been in the private sector. I've been a teacher. And, you know, I'm a counselor, I'm a cop, I'm a teacher, I'm a coach, I'm a farmer. I'm constantly trying to plant people seeds in people's minds with the hope that it's going to grow, whether it's during their term of supervision or not. But that's the real reward for me, is when I see something that I've been teaching people over and over and over again, and you don't think they got it, and then they put it together, especially at the end. The other way we do it is the obvious way. It's conditions. If the court imposes a number of conditions, they come in a lot of different forms depending on the case, and the judge is very individualized with how they decide what conditions apply to any individual. And I'm not going to go through this list, but the way I break this list down is it really boils down to communication and being truthful and following the law, just like everybody on this call does. Now it can get pretty technical at times. We have, you know, warrantless search conditions. We have location monitoring, which is an ankle, most people refer to as an ankle monitor. We deal with sex offenders, and their lives are monitored digitally. So the point being is it's individualized, and there's a lot of different methods that the court can give us to help us do our job. And then I'll end by kind of getting into some more of the weeds. Well, what does supervision look like? And it can boil it down to 3 words. We monitor, we restrict, and we intervene. The monitoring is the collection of the information, whether it's on their behaviors and or their activities, maybe even the people they associate with. You know, the restrictions are going to be based on that risk level. And again, a person could come in at a low and become a high could become a low. It just depends. And then we get into violence trailers assessments as well. And many of the risk factors that I was speaking of are, you know, you have your static and your dynamic, but then you get into the more daily risk factors, like something bad happens on any given day, and it triggers them, it sets them off. So we're constantly adjusting to that. And as you can imagine, my day is, I can come in with the best schedule and the best intentions, but it can blow up in a skinny minute. So that is us in a nutshell. I hope I've covered the basics. I really want to give us some time to ask questions and try to provide some answers.
Okay, we have questions. We will fulfill your request, and I'm going to ask you one and then Sharon and go back and forth. Questions that came in. What do you call, I'm just reading what was written. I haven't looked at this one. What do you call when you are supervised rather than go to prison? Is that probation? Is that parole?
Supervised rather than going to prison?
That's the question.
Yeah, that sounds kind of like because I know the state has supervised probation, unsupervised probation, and I don't want to give a wrong answer. Yeah, but it sounds similar to it sounds similar to probation. I think is as far as terminology, because it's freedom with conditions if you're not going to prison. Does that make sense?
Makes sense to me. Sharon, what's an Alford plea?
That's a great question. An Alford plea, so there's some case law that came back to the North Carolina Supreme Court quite a while ago, and it was a case called State versus Alford. And what an Alford plea is, it is a guilty plea. You are pleading guilty to an offense. However, you are saying, rather than saying, I am guilty for this offense, I'm pleading guilty in my best interest. It is in my best interest to take this plea that has been offered to me. So when someone pleads guilty pursuant to Alford, we make sure that the judge is aware of that. Now, you're still being treated as guilty, whether you admit guilt or not. So it's the same as pleading guilty, but you're saying it's in my best interest. And typically I would have my clients plead guilty pursuant to Alford, or I would present that to them when there is what is called a scripted plea. And that is when the district attorney and defense are on the exact same page. We know exactly what the outcome of court is going to be because it's all written into the plea transcript. So there's no wiggle room there. The judge is not going to impose any additional conditions. This is what the term of this plea is. So in that situation, is it in your best interest to plead guilty because you're being offered this, or would you rather outright plead guilty? But that's what an Alford guilty plea is.
Thank you. FJ, that one for you. How many times can someone on supervised release or probation violate the terms before you take the biggest step, like sending a person back to prison?
The easiest answer for that is it's so incredibly individualized. There is no one answer. Obviously, there is a tipping point. We are in the business of opportunity. The example I would give is the conditions on your judgment might say you can't be involved in a federal, state, or local crime. Well, you get stopped by the highway patrol and you got a traffic ticket for speeding at just over speed limit and a seatbelt violation. That is not to say that we couldn't hold you in violation of that. It's still a violation and it doesn't go away, and we'll record it. But something like that, it's going to be a misstep. We'll probably monitor it in court. But the hope is you talk about it, you learn from the experience, and then we move on with hopes that that person is going to learn that lesson and know they got to put their seatbelt on and slow it down a little bit. Obviously, you get caught with guns and drugs or be involved in some type of violent crime, your scale is going to tip pretty quick. But we give people an amazing amount of opportunity to be successful with the expectation that they might mess up a little bit. But that's sometimes okay, depending on what that mess up is. And it brings up another good point, is something that I've learned over time, is what is success? And I have, it's very easy to come into this job and realize that, I have a certain thought of what success looks like. But in my world, somebody that has grown up smoking marijuana every day since the day they were 13, maybe by not smoking every day, smoking 3 days a week, that's progress to me. I would even call that success. Are they still in violation? Are they still being tested? Is it still being calculated behind the scenes and not going away? Absolutely. But those are the things that we work with day in and day out.
That's a complicated answer to a complicated question.
Sue, can I jump in on that? Just
Sure.
a little bit on the state side. I also just want to say that stateside, ultimately it's up to the judge. It's in the judge's discretion when it comes to probation. Our state probation officers, they provide recommendations when they file a violation report. And if there is a violation that is found on that probation violation, then it's up to the judge. I have been in situations where I've been in agreement with the probation officer. We have agreed that it's in the client's best interest to continue them on probation. And depending on what those violations are, if a violation is found, it's up to the judge if they want to revoke your probation and activate a prison sentence. It's up to the judge if they're going to continue you, if they're going to send you on what is called confinement in response to violations, a 90-day CRV. It really just depends on what the judge decides. So even though you might be on the same page with a probation officer and you have an agreement, ultimately it's up to them, at least in my experience.
And it is different between federal and state probation, right? There's
what was that question, Sue?
There's a difference between federal, the way you do it, and the way Sharon may be a little more working with it on an everyday basis, because she works more locally. Did I get that right?
Yes, I handled the state side. So yeah.
Okay.
But to her point, I think the goal remains the same: keeping the community safe, giving people an opportunity to change, but also what she said about recommendations. I tell my clients, I don't revoke anybody. They revoke themselves. I just report it. And within that report are a lot of different things to include the violations and how they're responding to the things that we've been trying to do, but also the technical aspects of the whole matrix of things with our recommendation. But ultimately, the federal judge has the ability to do what he or she wants to do within the confines of the law.
Good to be the judge. Sharon, I've got a question for you that's not going to be easy to answer. Is there more pressure on low income or minority defendants to accept plea bargains?
I would say it really depends. And the reason I'm going to say that is it depends on what the underlying charge is. Now, I do see a lot of this with the community that our firm helps. And I will say that ultimately, if someone chooses to not accept a plea, then the case goes up to trial. We pick a jury, we have a jury trial if it's a superior court case, and there's a verdict at the end. With that being said, I will say it really depends on the case by case specifics, because there are a lot of differences in, having more, not necessarily like conclusive evidence, but it's a difficult position to be in, because there are more reasons why, in my experience, I feel people in different socioeconomic situations and backgrounds might accept pleas, or why there may be more pressure on them to accept a plea. Let me give you an example. So if you have a single parent who has this criminal offense that's pending, and they are the primary caretaker, they've been in custody, their kids are with another family member, and they don't know their well-being status, and they're in a position where, if this is the only way that I can get out of custody and get back to my kids, then yes, I'm going to take that plea. That's very different than someone saying, oh, they got me. The cards are stacked against me on this one. The evidence just isn't good, because there's more to lose if that person is in fact convicted. Is it right? Absolutely not. It's one of the most disproportionate things out there, but it does exist. And it really is case by case, personalized, because you don't know what someone's personal struggles are or what their personal motivations are. I have clients that I speak with on a daily basis that struggle with things just like that. They have sick family members that, if I'm not out to get my mom to her doctor's appointments, she's not going to get her treatment. And I'm in here right now, so this doesn't help anyone. So I just, whatever it is, Ms. Dunmore, just whatever it is, we'll take it. If I can get time served, we'll take it. So I do hear that a lot. I will say that I think it's a cross race, but I would definitely say that I do see it with lower socioeconomic backgrounds. It's not necessarily a racial aspect, but I do see it with my clients that I'm appointed to and the clients that come to our firm that are in a tougher financial situation.
Thank you. That one's complicated too. FJ, I've got one for you. Do your clients have access to all the community services they need to be successful? But if not, what would you like to see more of in this area?
I would say there is a number of resources out there, a number of people that want to help other people reentry, during reentry. There's a lot of money being devoted to it. I do see one gap, but it's not just with the justice served population. It's really across the board, and a lot of it has to do with housing. Coming out, not having much work history, maybe not having a job right away. I mentioned sex offenders earlier. The restrictions that they have they're heavy. So I would like to see more housing options, because it goes back to, I think I covered it earlier. If somebody is worried about where they're going to rest their head at night, then they can't focus on me trying to teach them to change their thinking. Or, and it's also, I think living on the streets obviously is going to put them in the circles of more high-risk populations, and then you increase your drug use and alcohol use and things like that. So housing, and that's where I've had some conversations with Jody in the past and gone to some meetings, but it's a problem. I mean, we talk about it a lot, but there's no real good answer at the time.
Housing is something that the Human Rights Department is seriously focused on. It's an issue for a variety of populations around here. All right, Sharon. This one's a little. Okay, prosecutors have to share evidence, but do they have to share it before I'm offered a plea bargain?
Not necessarily. So I'm going to speak about Guilford County, for example. We actually have a screening courtroom in district court. Before your case gets indicted to Superior Court, your case gets screened to see if it's going to be presented to the grand jury. In that situation, then the district attorney's office will look at the merits of the case, see what evidence they have, see what elements of crimes that they can prove. And typically, if they're going to offer a misdemeanor plea offer before it gets indicted to Superior Court, that's where it would happen. They don't always have to provide you with evidence in that situation, but they do. Here in Guilford County, they will provide you with a police report. They'll show you the summaries, basically what the officers observed. And going back to what I said previously, even if they don't provide that information, it's so important to understand that without having that information, and you're entitled to it as of right, you file your discovery motion, you are entitled to that information. If they don't provide it, you can compel that information from them. And before you prematurely move on anything, before you approach the DA for a plea offer, or if the DA is providing you with a plea offer, you want to know why are you not proceeding on the original charges? Or why are we so quick or willing to reduce charges down? I want to see your evidence. So even if they don't necessarily provide it, it is absolutely essential to have that information before making any decisions.
Good, thank you. FJ, I've got a complicated question here. It has to do with kind of what you can do. So what does monitoring look like for a person under supervision? What can you look at or check out in my life? Can you read my email, my postal mail, phone calls, my texts? What is it that you can do?
So some of that is going to be dictated by the court and the conditions that they give us, okay, or put on the judgment. On the surface level, things like simply meeting with the person, meeting with the person at the office, meeting the person at their home, meeting them on a curb, meeting them at work, those various locations, sometimes announced, sometimes unannounced, to get a real world perspective of what it is exactly they're up to. Criminal record checks. I can enter people into a national database. So if they have contact with law enforcement and or law enforcement's inquiring about them, or somebody that even sounds like them, I'll probably get a notification. I can research that. Financial investigations. Those would probably be some surface level answers. But as you said, it's complicated. And we've been talking a lot about.
It's 100 apples, and you take 30. How many do you have?
Hang on a minute.
What?
Somebody ask a question.
I got it. Okay.
We've been talking quite a bit about just individualized plea arrangements, individualized supervision. It's contingent on so many different factors, but it's for the most part going to be dictated by the court.
Okay. This may be a quick one for FJ. Can a person move to another state after being released from prison while still on federal probation or supervision?
Well, there's probably a couple of different things I want to say about that. Earlier, I had mentioned working with Bureau of Prisons case managers, and they send us a supervised release plan investigation, basically saying, like I said, I want to live with this person in this place. Some people try to move and go to another district. But for example, if I get arrested here in the Middle District of North Carolina on a gun case, I am essentially under the Middle District of North Carolina umbrella. So if by some freak chance I'm in prison, I'm getting ready to come out, I work through my case manager and I say, I want to just start on a clean slate and I want to go to New Orleans, Louisiana. You know, they can send that request to New Orleans, Louisiana, but New Orleans doesn't have to accept it. Now, once they come out, let's just say I release to North Carolina and I'm living here in Greensboro, and then I develop a relationship online and I want to move to Los Angeles, California. And my girlfriend, she's going to help me get a job, and I can put that in, you know, kind of firm those things up. You know, what I tell my clients, I was actually just talking to one last night, he wants to move to Texas. And the conversation revolved around kind of what can I sell? Sell about you to where, you know, you have some resources there, you have somebody you could live with, you have a job lined up. Because again, it's about setting somebody up for success and not failure.
So people can move, but it requires
work, a lot of work and a lot of information. And it's not a guaranteed yes. And then to make it even more complicated, that district could accept them temporarily kind of as a tryout. And if it doesn't work out, they could send them right back here.
Oh, good.
So yeah, you can get into the weeds on that one.
Yeah.
But it's
Sharon?
possible. It's not a no, but it's not a yes either.
Okay.
Hey, Sue,
Wow. Yeah.
this is kind of related, not really, but I did want to say it. Also, on the state side of things, if you are placed on probation and you live in another county from where the offense occurred, you can actually request that a judge transfer your probation to that county so that you can be supervised in another county. So you get charged in Guilford, you're convicted in Guilford, but you live in Orange County. You can ask that you be supervised in Orange County. So not really the same thing, but I thought it was worth mentioning.
Yeah. It is worth mentioning. And we've got a question for you.
Sure.
What is your estimate if you can, of what % of innocent people take a plea bargain to get out of pretrial jail, but then they have to live with the consequences of that record? Do you think it's a lot of people, a few people? What do you think?
I couldn't tell you.
Early, our first session for Let's Talk Law, Don Vaughn talked about expungement. And there are certain kinds of crimes that can be expunged and some can't. If you take a plea bargain, can you later, if you want, file for expungement?
So it depends on what the offense is. If it is an offense that qualifies under the expungement statute, then yes. Now, on the felony side of things, there are a lot longer waiting periods. There are limitations on the amount of expungements you can receive. Certain offenses just aren't eligible at all. So if you're eligible and you wait the requisite amount of time afterwards, then it shouldn't be an issue, but that is completely case specific, and that's crime element specific. Wow, I can't speak right now.
It's getting late.
A long day.
It's getting late, you guys.
Okay, we're going to go with one more question, and then I'm going to ask Jody to please put into the chat the link to the survey. The survey, before we get to the big last question, it's very important to us that you fill it out. It won't take 5 minutes to do. It'll probably take less than that. Just a few questions, and we want you, what you write in that survey helps us plan future programs. This is the first series, Let's Talk Law. We want to do more and we want to make them better. So if you'll please fill out the survey, it will help us. Okay, I have, okay, for FJ. In your line of work, Are there identified issues that cause recidivism going back to jail?
Well, I think we talked about them. It's
Okay,
people's decisions making. It's the people they associate with. It's their addictions. It's their mental health. It's such a wide array of things that.
all right, and you did talk about it. I just am reading questions. Is there a checklist that people being released from incarceration have in hand to track the things they should consider doing to effectively transition back to the quote unquote real world?
For me,
Yeah, anybody wants to answer it.
I will say this, we do have some resources online at our Middle District North Carolina website. As to what specifically those are, I don't know. But I would also say that's where we try to form that relationship on that front end. And we go to the halfway houses, we go to Butner, and we are trying to answer people's questions as they come. So
Okay.
when they technically release from federal prison and start their term of supervision, they already have a pretty good idea of how we operate and what the expectations are.
Sharon, do you have anything you'd like to end with? Any comments?
Well, if anyone has any further questions, I'm happy to receive those via email. Now, I can't give any case specific information, but if you do have a legal matter, and even if you're not sure if you qualify for our services, feel free to give us a call. That's why we exist. Like Sue said earlier, everyone deserves counsel. Everyone deserves a right to counsel and to make sure that their rights are being protected by people that care and understand. So if there's anything that Triad Legal Group can assist with, we're not just criminal. We handle everything under the sun with the exception of bankruptcy and real estate. But if you have any legal matters, give us a call. We're here. We're happy to serve our community.
Thank you for your time tonight. FJ, do you have closing comments?
I would just say, you know what, I live here. I live in this community, and it drives a lot of what I do. I want to also probably should put a shout out to Jody and Love and that Thrive GSO group, because I can't do the job myself. And there are a lot of resources out there that I learned through going to different meetings, many of which seem to be organized by Jody and Love. So I want to plug you guys. But it's really, the job's too big for one person. And I spoke a little bit about relationships with the clients or the people we supervise, but a big part of it too is the relationships I have, that I developed through these meetings and things like this tonight, because it's very powerful if somebody's having a very specific situation and they need help. And then rather than send an email or something, I can literally pick up the phone and or just meet them somewhere and introduce them to a person that might be able to provide that level of support that they're looking for. So this, I see myself in very much the relationship business. And this is not, let's rack them up and throw everybody back in jail. It's so much bigger than that. And our goal is really to keep people out.
That was super. Thank you both very much. We got their time, their expertise, and a whole lot of information. Again, let me remind you, please fill out the survey. Jody's put the link in. I think I did a couple times too. And mark your calendar for the next Let's Talk Law presentation on March 3rd, same time, same place. It's, can they do that? The Fourth Amendment search and seizure. And that should be pretty rollicking because it'll be interesting. If you have any other questions, when you get the survey, there will be links at the bottom to look at previous recordings of these sessions. There'll be a way to get in touch with Jody and the Human Rights Department at the City of Greensboro, and we can get your questions to our speakers if you think them up later. But besides that, Jody, do you want to, got anything? No?
No, if
Dr.
anyone's
Jones?
if anyone's interested in signing up for emails with Thrive GSO, you can join our network. We're free. You can become a member for free. All we need is your email address so you can sign up and get information and be connected to the reentry support group here in Greensboro. But please do take that survey. It's really helpful for us. It helps us design the next courses, and these are for you. So if you can tell us, you have the opportunity to suggest topics as well. But thank you to Sue. She's played a key role. Other commissioners are here as well. Many thanks to our commissioners. You're doing an awesome job.
Thank you.
Jody,
And-
this is Commissioner Smith. Can you please add me to that list?
I will.
Thank you. I can't put it in the chat. I'm sorry, Sue. I didn't mean to interrupt you.
No problem. So for everybody else, it's Thursday, the weekend's coming. Please stay safe, stay healthy, and stay warm, and we'll see you next time. Thanks for being here.